Hey Facebook friends, this is another Facebook Live session with the Accident Recovery Team. I'm Todd King over here at the firm. Today I want to start by addressing some of the questions that we had received when we did some radio question and answer. Maybe you didn't catch it on the radio, but those questions were good questions, and so I thought I'd give those answers today. Of course, while I'm going through some of these earlier questions from the radio, if you have any questions, go ahead and send them in to us. We can answer them live. We get those received in here. I'll be happy to answer them for you. My primary practice is in workers' compensation, so the questions that I'm addressing today are primarily on that. But any other question you want to send in, go ahead. That's fine. And of course, I should start just as a reminder. You can call us at 267-TEAM. You can go to our website at 267team.com or accidentrecoveryteam.com. So you can get a hold of us that way if you ever have any questions. Consultations are always free, so it doesn't cost anything to call or email or get a hold of us to ask a question. All right, let's dive into some of the questions. One of the questions we had on the radio the other day was, does my employer have to have work comp insurance? And if he doesn't, what are the effects if I get hurt at work? That was a great question, which is why I wanted to bring it up today too. And first of all, let's cover when the employer needs to have work comp insurance. The law requires that if there's an employer that has an aggregate annual payroll in excess of $20,000, and by aggregate, that means that you add up the salary of all the employees, and if that adds up total more than $20,000, and that's a very low threshold, it doesn't take much to meet that, then under the law the employer would be required to have work comp insurance. There are some exceptions. They can exempt out, for example, if they choose to be self-insured or if they become part of a pool. So otherwise, they would be theoretically required to have work comp insurance once they hit that mark. If an employer, if you've been hurt at work and you've got an employer that tells you, I don't have work comp insurance, that either means they're saying they're too small and they don't have work comp insurance, they weren't required to have work comp insurance, or maybe they were supposed to, but they just didn't buy any and they don't have any. So we'll address both of those. If you have an employer that's not going to be covered by the statute, meaning that they weren't required to have insurance, that doesn't mean that you wouldn't have a claim necessarily. You would still be looking at it from a fault standpoint, a tort standpoint. If you've been hurt at work and it's because of the negligence of your employer, you would still have a claim outside of work comp, and we can address that. That would be a very fact-specific case. So call us and we would walk you through whether your injury would fall into that category. If instead we're dealing with an employer that is supposed to have work comp insurance and either their insurance has lapsed or they didn't buy any, you still have your claim. There is an entity at the state level called the Kansas Work Comp Fund. All the insurance companies that are allowed to do business, according to the insurance commissioner in the state of Kansas, are required to pay into this fund. And it is for providing the same benefits that the insurance company would be required to give you in the absence of an insurance company. So they would step in and pay the medical bills, provide the treatment, pay for off work status, pay for the disability compensation. So you would still have a claim even if your employer is trying to tell you they don't have insurance. Okay. Another question that came up was, what is a subrogation? I was really kind of surprised to hear somebody ask that question because I don't get that question too often from people, because that's a little more of a complex legal question than most people would bring up. Subrogation arises when, if you've been hurt at work, which puts you in the category of asserting a work comp claim to get your benefits, but you've been hurt at work due to the negligence of some party other than your employer or you, and this will come up sometimes, like if it's an auto accident, you were in the course of employment, that you're out on the streets and you get hurt. It can come up where you're working for your employer, but you're delivering product or something to another entity, and that's where you get hurt. If it's not any claim against your employer would have to be through comp, but a claim against somebody else would open the door for you to assert another claim outside of work comp against that person or entity or business for their negligence. Subrogation is when, after the work comp insurance has paid your benefits, whether it's paying for medical bills or paying for your disability compensation, and you then go after the fact and assert your claim against this third party, this other party, collect money from them, you're not going to get to double dip. And so the work comp insurance is going to be first in line to ask for their money back out of the money you received against the party that's at fault. Typically, work comp has a limited amount of compensation that they will pay. There are caps built into the work comp statute. If there is ever a second claim to be made, it's typically worth more money. There are more types of damages that can be claimed in those cases. So the second claim frequently is worth more. And if you can recover that, we negotiate a reduction in the lien that goes back to the work comp carrier so that you maximize recoupment as much as possible under both claims. That's a complicated one, but that was a question that was asked, how does subrogation work? That's how subrogation works. I did want to talk also, I made a note, this isn't really a question I get, it's more of a category of questions. I get a lot of questions from my existing clients on how to deal with their employer during the course of a work comp case. And those questions can come in lots of different ways, at lots of different times during the case. But they kind of all fall into that category. How do I deal with my employer during the case? We had previously talked during Facebook Live about giving notice and can they fire me for asserting my claim. So I won't go over that again, but assuming you've already given notice of your injury and you've already asserted your claim, now we're into the point where you're being assigned to a doctor, you're in treatment. Now let's take it from there. A lot of times I get questions or comments from my client that are telling me their employer maybe doesn't believe that they're hurt. My short answer is this, and I'm talking to you employers, I don't care if you believe if they're hurt or not. Here's the answer. Once the doctor is assigned under work comp, that doctor is going to make an assessment as to whether they think it's work-related or not based on the type of injury that was alleged. That's not the end of the argument, however. We have the right to bring in a medical expert to also address that issue, and that ultimately can be addressed by the court as well. But once a doctor has confirmed there is an injury, or once the judge has confirmed there is an injury, it really no longer matters whether the employer believes there's an injury or not. The treatment course is going to be directed by the doctor. For the employer to tell the injured worker that, I want you to treat faster, or can't you get into the doctor any faster, or can't you change these restrictions, and I'll talk more about that in a minute, is useless because it's not up to the injured worker, it's up to the doctor. The doctor will dictate the course of treatment. The doctor will dictate what restrictions are put in place for work. That's kind of the next category where I get a lot of questions. I have employers, as reported to me by my clients, that will say, we don't think these restrictions are appropriate. Again, it doesn't really matter whether the employer agrees with the restrictions or not. Those are coming from the doctor. Asking the injured worker to have the restrictions removed is inappropriate. It's not the injured worker that imposed the restrictions. It's the doctor. Challenging whether they're appropriate or not is inappropriate. It's not up to the injured worker. It's up to the doctor. That is the doctor that the employer's insurance designated. So they're the gatekeepers of the course of treatment. And as to the restrictions, they're the gatekeeper of whether the injured worker should presumably be at work, not at work, or should be on some sort of light duty status. If my client who's injured is allowed to return back to work in some light duty capacity, you have to follow the restrictions. The phone calls that we get are either they're not following my restrictions, or they're following my restrictions but it still hurts to work. So if you've got a work comp case and you're injured and you don't have an attorney and you're dealing with that situation, here's the answer. Since it's going to be designated by the doctor as the gatekeeper of whether you work light duty or not, and that doctor maybe isn't listening to you when you say they're not following my restrictions, or they're following my restrictions but it still hurts, our argument is then they're the wrong restrictions, and there is a remedy for that. We have the right under the work comp statute to file for a change in treating doctor. Even though the insurance company gets to appoint your treating doctor, we have the right to file for a change in treating doctor. So the first line of defense is communicate openly with the doctor about what your employer is actually having you do. If the doctor gives you a set of restrictions and you go back and they're not following, you got to talk to the doctor about that. Don't ignore it. Let the doctor know. he might change the restrictions for you, or he may remove them entirely and say, I want you completely off work. But if he gives you restrictions and they are following them, but it still is causing a problem for you, you need to communicate that to the doctor as well. His response should be to amend the restrictions to fit what you're doing until it stops bothering you. If you have a doctor that's not responsive to either of those types of complaints, you need to get a new doctor. And the only way to do that is to file a motion with the court for a change in treating doctor to get a doctor that will address those types of concerns. The other issue I get with people dealing with their employer is the employer trying to tell them, you need to drop your case or you need to settle your case. Again, once somebody has confirmed that you have a work-related injury and the claim has been filed, you don't get to pick when it settles. Your employer, if they're telling you you need to get the case resolved, you need to tell them it's no longer in your control. It's been turned over to the employer's work comp insurance. They're treating you, they're dealing with you. We can't talk settlement until treatment is over. We have to get all the way through treatment to the end until you attain what's called maximum medical improvement. Only then, and if they try to put you at maximum medical improvement too soon, we can challenge that. But at some point, you'll reach actual maximum medical improvement, and that is when we move from the treatment phase of the case to the damages phase of the case. And then we can start working on the possibility of settlement. Until then, if you've got an employer that's trying to pressure you, you can tell them it is not within your control. It's up to the doctors. If you are returned back to work on light duty but at a new position that pays less, or the doctor limits you on the number of hours you can work, or your employer limits you on the number of hours you can work, you have a claim to make for those lost wages. It's called temporary partial disability benefit. You should be receiving 2/3 of your pre-injury gross average weekly wage when you are off work, entirely off work. Either the doctor's taking you off work or your employer cannot accommodate the restriction. So you're completely off work. You get 2/3 of your pre-injury gross average weekly wage, subject to a cap. But if you return to some sort of partial work at reduced wage, you're entitled to 2/3 of that lost difference. And you don't pay taxes on work comp benefits. So that's 2/3 non-taxed of your pre-injury gross average weekly wage before taxes. Sounds complicated, but it's not. If you have a question, give me a call. Consultations are free, as I've said, so any of this that you want me to follow up on, give me a call. If I'm not in, you can ask for Gary. He handles workers' compensation as well, Gary Alvin. If you have any other question about any other type of case, even a non-work comp case, give us a call. Sean Brennan in our office, Norman Douglas in our office can talk to you about any car accidents, premises liability, products liability. But I think that's it for today, unless we had any other questions come in. No? So those are the ones I wanted to hit on that I received recently and that I receive often. So I wanted to address those with you. Again, you can reach us at 267-TEAM or 267team.com. So if you have any other questions, track us down, give us a question, we'll give you an answer. I don't think we're going to have another Facebook Live session until we get into January. So, Merry Christmas, Happy New Year, drive safe.